We are recording.
Thank you so much. Good morning. Welcome to the appellate court. We're back in session. This is now the 11:30 case, Jason DEGUMBIA versus GEICO General Insurance Company, AC number 42494. We are conducting this hearing pursuant to on the Microsoft Teams platform. The argument is also being streamed live over the Judicial Branch's YouTube channel. And with respect to that, please do not disclose any protected information that may exist in this case, if it does exist. I doubt it does, but just be cognizant of that, please. The first order of business is to have everybody introduce themselves so that we can make sure that we can all hear and see each other. We'll start with the judges and then counsel for the appellant and then counsel for the appellee. I'm Judge Prescott.
Good morning, Judge Clark.
And good morning, Judge DiPentima.
Good morning, Erica Barber for the plaintiff appellant.
Good morning, Logan Carducci for the defendant appellee.
Okay, it looks like we can all see and hear each other. Please make sure to keep your microphones muted while you're not speaking. That applies to everybody, just so that we can avoid ambient noise. And we'll remember to turn off our mute buttons when we need to talk. Each side, as you guys know, have 20 minutes for argument. If you're the appellant, you wish to reserve a portion of that 20 minutes for rebuttal time, please let me know when you begin your argument. I'll hold up this very fancy sign when you have 2 minutes left. Attorney Barber, you ready to go?
Yes, I am.
Okay.
May it please the court. My name is Erica Barber. I represent the plaintiff appellant. With the court's permission, I would ask to reserve 5 minutes for rebuttal.
You got it.
The sole issue in this appeal is whether when a claimant has failed to meet a condition precedent of making an underinsured motorist claim, the correct result is judgment for the defendant insurer. Mr. DEGUMBIA maintains that where the exhaustion requirement pursuant to 38A-336B has not been satisfied, but may be satisfied in the future, as the court and the parties expressly acknowledged here, the merits of the underlying case are not ripe for review, and therefore the case should be dismissed without prejudice for lack of subject matter jurisdiction. I want to be clear about what is in dispute and what is not in dispute. First, there is no dispute that Mr. DEGUMBIA had a policy with the defendant in effect at the time of his injuries and that all of his premiums were paid. Secondly, there was no dispute that the sum of the limits of liability under the applicable insurance policies, here the tortfeasors policy of $20,000 and the UIM policy secured by the city of Meriden in the amount of $40,000, was less than the coverage available under the underinsured motorist provision of the GEICO policy. The issue thus was what the correct remedy was when it became apparent that Mr. DEGUMBIA had failed to exhaust Meriden's UIM.
Attorney Barber, I'm struggling with, I think, what might be one of the fundamental premises of your whole argument.
Yes.
And that is, okay, so we have a judgment for the defendant on summary judgment, which I don't think you really, I mean, I know you disagree with the form of the judgment, but with a conclusion that there has not yet been exhaustion of the necessary policies in order to bring this claim, right?
Yes.
You agree
Yes.
with all of that, right?
I agree with that.
But you seem to think or argue that somehow precludes or bars a subsequent successful suit after there has been exhaustion of the necessary policies.
Well, Your Honor, I believe under this court's cases, for example, we've cited Boone. I believe that's the way you pronounce it. In that particular case, this court concluded that a failure to meet a procedural requirement would preclude the plaintiff from prevailing in the second action. So, I mean,
explain to me the procedural context of that case.
So in Boone, the issue was, Your Honor, that the plaintiff had failed to make disclosure of an expert, I believe, and then was precluded under the court's order from doing so. And the defendant in that case argued that because he was not going to be able to present an expert, that therefore he was not going to be able to make out his claim. And then when the plaintiff subsequently brought suit, the defendant argued res judicata, collateral estoppel. And
that just seems so different to me. First of all, that's essentially, litigation misconduct is a little strong of a word, but failure to do the things that you have to do to successfully prosecute the initial action. This is different because there was an open question about whether or not exhaustion was required in the manner in which the defendants argued there must be exhaustion. And so there was an adjudication of that. And what we have is a judgment that says, yeah, you got to exhaust first. So go ahead and exhaust and then bring another claim if there's a denial of a claim. I don't see the problem with that.
Well, Your Honor, I mean, if GEICO were to concede that it's a different transaction or arising from a different claim, assuming a successive lawsuit, then yeah, I agree that would be a different story. But I think as a general rule, yes, Your Honor.
Why do you need the other side to stipulate to something that is either true or not true as a matter of law?
Well, not so much to stipulate, but then I suppose the issue would be moot. But as a general rule, I believe the cases hold that where the court does not have authority to grant summary judgment because the issues are not ripe for review, then a dismissal should enter. Yes, Your Honor.
So anytime someone brings a claim for breach of contract or to recover on a contract, and there's a condition in the contract that hasn't been met yet, that must be met in order for liability to attach, the Superior Court lacks jurisdiction to even adjudicate that issue. Is that what you're saying to us?
I suppose it would depend on the circumstance.
Tell me what it is about this statute that makes clear that the court actually lacks jurisdiction to even adjudicate a question about liability under a contract. So the cases you cite to are exhaustion of remedy cases, for the most part under the UAPA. Those are, by their very nature, statutory causes of action, and the case law is very well established that you need to conform strictly to the requirements of those statutes, or else those statutes don't apply, and therefore the court lacks jurisdiction. And in most cases, there isn't a waiver of sovereign immunity that would otherwise be required of the state. I just don't see any analogy between that, or even frankly cases that adopt the statutory requirement that people arbitrate matters. I mean, those go to whether or not the court can even hear the case in the first place, not whether or not something hasn't happened yet that would need to happen in order for liability to attach pursuant to a contract. Unless I'm missing something. Can you point to something in 38A that makes clear this is a jurisdictional defect?
Well, Your Honor, I think the court's cases are not clear, which I think the parties agree on. So there's two lines of cases, essentially. There are the cases that, there's the case that the defendant cited below, which is Continental Insurance versus C.B. Herbersky, which states or held that a single policy is exhausted only when the limit of coverage actually has been paid to the claimant. Subsequently, that's adopting essentially the statutory language. Subsequently, there were the cases that the defendant has cited, which is Serrano, McGlinchey, Hutkowski. Those are statute of limitations cases in which the Supreme Court stated, but didn't hold, but stated in dicta that that you didn't necessarily have to commence an action after exhaustion. However, there is no holding in any case that says one way or another. Looking at the analogous cases, and you've mentioned, the cases failure to exhaust administrative remedies, but abuse of process cases are another example where I guess you would say they qualify under sort of a prudential ripeness analysis, which is where the court declines to hear or declines to consider an issue because it's contingent on a future event. And I think that's exactly what happened here. I think everyone acknowledged that the case was contingent on a future event. And therefore,
but that's what exactly the trial court was adjudicating, was whether or not that principle was in fact true. And I simply don't see how the court lacked jurisdiction to do that once it found that that precedent, that pre-existing event hadn't occurred yet.
Well, I mean, the justiciability cases are analyzed under a subject matter jurisdiction framework. So, you know, I mean, and essentially those cases say that dismissal is appropriate. For example, I think we've cited the Pursuit Partners case, which was an abusive process case, where the court, the defendant moved for summary judgment, and the judge converted it to a motion to dismiss, essentially saying there's an element of abusive process here that has not yet been satisfied. And so therefore the correct result is not summary judgment, but instead dismissal without prejudice.
Attorney Barber, could I just, when did this, was this raised to Judge Sizemore, this argument?
No, it was not, Your Honor.
So she decided what was before her, and your objection did not say, by the way, this, you don't have subject matter jurisdiction here.
No, Your Honor, but I mean, as the defendant has noted, I mean, subject matter jurisdiction, obviously you don't waive that. It can be raised at any time. And I think parallel to that, if you're talking about something which is sort of quasi-jurisdictional, okay, so obviously the cases are complex. We have cases dealing with constitutional rightness, prudential rightness, quasi-jurisdictional claims, such as, for example, the prior pending action doctrine, where the court is essentially treating it the exact same way. And so the issue, therefore, yes, Your Honor.
No, finish answering, Judge.
So therefore, the issue becomes when you have something that goes contrary to public policy, which is the case here, where the plaintiff has contracted for insurance, and he's entitled to recover at some future point, and he would not be made whole again if GEICO were to argue that he was stopped under the prior judgment, then that's something that's obviously contrary to public policy, and we would argue that it should be treated the same way. Yes, Your Honor.
The statute doesn't actually require that every insurance contract include a provision that would require an insured to exhaust all other policies, right? It just says those types of provisions are enforceable, right?
I'm sorry, are we talking about the statute?
Yeah.
So the statute states that an insurance company shall be obligated to make payment to its insured up to the limits of the policy's uninsured and underinsured motorist coverage after the limits of liability under all bodily injury liability bonds or insurance policies applicable at the time of the accident have been exhausted by payment of judgment or settlements.
Right, but I mean, I suppose an insurance company could be more generous than is required. I mean, they could say, it wouldn't be illegal for an insurance company to say, we'll cover you regardless, right? It just says that.
No, I agree with that, Your Honor.
Yeah. Okay.
Yeah, I agree with that, Your Honor.
So doesn't the court have to adjudicate whether the contracted issue has such a provision, and from there determine whether or not, never mind, I'm sorry, keep going.
So here the insurance policy, I mean, GEICO's position was that the insurance policy did adopt, it was consistent with the statute, and that the language in the policy was also consistent with the law defining the host vehicle, defining Meriden's policy as controlling as the policy covering the host vehicle. Yes, Your Honor.
Were you able to find any cases in any other jurisdictions, all of which have uninsured or underinsured statutes, as far as I know, or very well most of them, where someone brought an action and the court determined that the insured hadn't exhausted other policies and therefore the court lacked subject matter jurisdiction?
Your Honor, I have. It's not actually cited in my brief. I'd be happy to give the cite. And I mean, Attorney Carducci hasn't had an opportunity to respond If we wanted to have supplemental briefing on it, we could obviously do so. But there is a case, there are cases out of Texas and Alabama, which similarly have decided that the issue implicates ripeness, where the primary policy has not yet been exhausted. For example, there's a case, Zebner versus Allied Property and Casualty Insurance Company, which is a Colorado case. It was in the United States District Court, which adopted Colorado law. There's cases in Texas and Alabama. Obviously, those are different statutory schemes, but those courts, yes, essentially have stated what I am arguing, which is that if something is contingent on a future event, there is no UIM coverage available until the limits of the liability have been. Yes, Your Honor.
And have you found any cases to contradict what Judge Prescott, was implying in his line of questioning, which jumped out at me instantly as well as I was reading the briefs, which is that somehow if you do bring a case too early and it's adjudicated by summary judgment rather than ripeness or other justiciability type questions, res judicata applies and you can't bring a subsequent action. Have you found those cases in this context?
Not in this context, Your Honor. No, I have not seen a case discussing what is the correct remedy. There are cases that discuss whether it's failure to state a claim or whether it's a subject matter jurisdiction issue. Yes, Your Honor.
Attorney Barber, I dropped the ball on holding up the sign. You've got about 40 seconds left.
Okay, thank you, Your Honor. I will address any questions in rebuttal. Thank you.
Okay. All right. Attorney Carducci.
Good morning, Your Honors. May it please the court. My name is Logan Carducci. I represent the defendant, GEICO General Insurance Company. I will just kind of to respond to actually Judge Clark's most recent question about res judicata. The court can take judicial notice of other cases pending. The plaintiff has actually brought a second suit alleging the exact same issues. In truthfulness, we have moved to dismiss because this is still pending. There's a prior pending action, the plaintiff has not responded to our motion. So there is a second suit pending.
Attorney Carducci, did you raise judicata in that motion to dismiss this newer action?
We did not, Your Honor. This court should affirm summary judgment because this case does not involve the exceptional circumstances that warrant plain error review. This case is very simple. The plaintiff could not prevail on his underinsured motorist claim against GEICO because under GEICO's plain language of its policy, he failed to exhaust all policies applicable. The plaintiff has really conceded this. American Southern needed to be exhausted. The first issue is whether that's a condition precedent to even be able to bring a suit, and it is not a condition. The plaintiff could bring suit and did bring suit. In this instance, the plaintiff brought suit, and then everyone later learned about the American Southern policy about 2 years into the litigation. At that time, the plaintiff could have brought suit against American Southern and still chose not to do so. This is a very unique situation. In April 2018, all of the parties learned about the American Southern policy, and the plaintiff failed to cite that party in until 4 days after judgment entered against GEICO. In that 8-month period between April of 2018 and December of 2018, the plaintiff could have brought American Southern into the case and did not. Could have brought suit, could have tried to exhaust that policy and failed to do so. It's not a condition precedent to be able to bring the suit. It just simply was not done. I believe it was also Judge Clark that asked that question about basically perfecting a claim versus bringing a claim. Although plaintiff must exhaust underlying insurance policies to perfect an underinsured claim, the plaintiff certainly need not actually have exhausted those limits to bring the claim. If you actually look at the language of the GEICO policy, suit can be brought within the 3-year period, even if the other suits have not been, or the other policies have not been exhausted. But at some point, especially on summary judgment, you do have to exhaust those policies. Just to hit a few more of the plaintiff's points. In response to summary judgment, the plaintiff spoke to the merits of the issues. The plaintiff did not raise this summary judgment versus dismissal issue, as Judge Padima pointed out, the plaintiff simply said summary judgment is not warranted because we exhausted the policy. Then the plaintiff said summary judgment is not warranted because the GEICO policy is excess. At no point did the plaintiff say there was a jurisdictional issue. The plaintiff cannot.
Attorney Cartucci, could I just interrupt? So it sounds like there's a statute of limitations issue facing the plaintiff. Is that correct?
With the American Southern policy, Your Honor?
With bringing another suit.
So if you're asking about the American Southern policy, actually, they just, because this court can actually take judicial notice of how the case proceeded since the appeal was filed, the plaintiff did bring suit against American Southern, and American Southern did not make a statutory or a statute of limitations argument, actually proceeded to defend the case and ultimately won on summary judgment on a different issue. So there wasn't a statute of limitation. I mean, there was, but because, and this is actually in the transcript from the summary judgment hearing, because the city of Meriden is a valued client of American Southern's, they did not dispute the statute of limitations.
Okay.
Yes.
Did anyone contest American Southern's motion for summary judgment?
No, they did not, Your Honor.
And that was on the grounds, I guess, that there was workers' comp available from the city? Yeah.
Yes, Your Honor. So the grounds were basically that pursuant to American Southern's policy, they are able to reduce the $40,000 policy by any workers' compensation paid and the tortfeasor. So it's $20,000 from the tortfeasor and $113 at the time, I think.
So American Southern is the carrier for both the workers' comp and the car.
Yes, Your Honor. So they actually got out on summary judgment.
So is that policy now exhausted?
Technically, exhaustion usually means a judgment and settlement. So I guess that's, but it's.
Well, there is a judgment.
I'm not sure, Your Honor. Yes, Your Honor. That's actually, I mean, that's not an issue for this case, but it's certainly an issue for the second pending case. It was brought in September, I believe, of 2020. And as I said, we moved to dismiss, but ultimately, you know, those issues of res judicata, the issues of whether it's exhausted will be dealt with in that case.
Well, is GEICO, GEICO hasn't yet alleged res judicata. Attorney Barber is concerned that it might. Have you ever had a case like this before?
No, Your Honor. In all honesty, no. This is a very unique case.
Okay,
these facts are very, again, sorry.
At this point, you've only raised the prior pending action doctrine.
Yes, Your Honor, we moved to dismiss a couple weeks ago. So yes, we've only raised the prior pending action doctrine.
Okay.
And just very briefly to hit a few more points, the use of the word premature is something that the plaintiff really focuses on. The trial court's memorandum of decision needs to be read as a whole, not in isolation. The use of the word premature, it's pretty clear that it wasn't an issue of ripeness. It was an issue of failure to, make a claim. There's no genuine issue of fact that they hadn't exhausted the policy. It was very simple. It was not an issue of ripeness or condition precedent to bring a lawsuit. The lawsuit had been brought. And to bring the lawsuit, all you need to do is allege that you exhausted the policies, and that was alleged in paragraph 12 of the complaint. And I believe that Judge Clark was kind of hitting, or one of your honors was hitting on the public policy issues. Again, this is a very unique case. This is not something that generally happens. In that 8-month time frame, generally a plaintiff would have brought suit against American Southern. Whether you think there's a statute of limitations issue or not, you generally would bring suit against that other carrier to exhaust that policy if you're looking to seek underinsured claims or underinsured benefits from GEICO. So this is not something that will have general repercussions for other cases. It's a unique case. And I do just want to emphasize, I know I spoke about this earlier, but the plaintiff did learn about this policy 8 months before the decision. It's actually on A33 of, I believe, the plaintiff's appendix. Defense counsel actually sent a letter to plaintiff's counsel saying this policy exists maybe something should be done about this American Southern policy, and nothing happened. Nothing happened in April. Nothing happened in July of 2018 when the City of Meriden insurance broker was deposed and she brought the policy. Nothing was done when summary judgment came about, when we moved for permission for summary judgment, and nothing happened until the memo of decision came out. Unless your honors have any further questions, we ask that you affirm. Thank you.
All right. Thank you, Attorney Carducci. Attorney Barber, you have 5 minutes for a rebuttal.
Yes, just to address a couple points. In terms of the complaint and what it alleged, the plaintiff actually alleged that he had exhausted the tortfeasors policy. There was no allegation that he had exhausted all of the applicable policies. And so the issue here, which also was an issue of first impression for Judge Sizemore, was whether or not the exhaustion requirement also applied to the other available UIM policy, which we agree was appropriately decided. Yes, Your Honor.
So the court did have jurisdiction.
Sorry?
So the court did have jurisdiction. It couldn't have decided that even if it didn't
Well,
have jurisdiction.
so as an analytical, no, I should put it this way. As an analytical framework, the law would appear to hold that, yes, you have to exhaust all applicable policies. But as a matter of ripeness, and I do believe or do agree that there is a lot of gray area in this regard, but the cases hold that if something is contingent on a future event which has not yet occurred, and it's not clear that the coverage will apply. And yes, no, they don't hold that in this context, but that's because there is no authority in Connecticut in this context. But analogous cases, for example, Cadle Company, which we've cited, which deals with a somewhat different issue of priority as to a claim against an estate, but it's the same idea in the sense that until that injury has occurred, the issue is not right, and therefore the court does not have subject matter jurisdiction. So I agree that it's different than a case involving administrative remedies, but I disagree that it doesn't fall squarely within the doctrine of whether or not this case was ripe for review. In terms of the, some of the procedural posture of the case, it was the position of plaintiff's counsel that exhaustion had effectively occurred because of the workman's comp benefit. And that is, of course, the position that the Meriden's insurer took. And that was why summary judgment was granted. And I'm sorry, I think something is freezing up here a bit. But in terms of the posture of the case now, yes, GEICO has moved to dismiss under the prior pending action doctrine, which again is another example of sort of a quasi-jurisdictional analysis, which we're suggesting is the appropriate analysis here as well. And if the court has no further questions, we would ask that the judgment be reversed or modified as dismissal without prejudice.
All right. Thank you to you both for your arguments. Hopefully we'll see you in the real courtroom soon. We'll take the matter under advisement and we stand in recess until 2 p.m.
Thank you.
Good to see you both.
Thank you, Your Honor.
Bye-bye as well, Your Honor.